Okay, now we're going to start to talk about our federal judiciary and how corrupt it is in New York State. They are not there to protect our rights. They are there to oppress them and to cover up for state officials. Thomas McAvoy, Con Shalakas, we're going to be going through a number of them. Civil rights. Now, the district court shall have original jurisdiction over any civil action authorized by law to be commenced by any person. Number 3, to redress the deprivation under color of state law, statute, ordinance, regulation, custom, or usage of any right, privilege, or immunity secured by the Constitution of the United States or by any act of Congress providing for equal rights of citizens or of all persons within the jurisdiction of the United States. That would include your constitutional rights to a public trial before you're in prison, your right to a jury trial before you're in prison, a right to competent assistance of counsel, the right to a court of proper jurisdiction, and so forth, and the right to due process and equal protection of the law. 1983. Every person who under color of state, any statute, which would be your judges, attorneys, or that work for the state, ordinance, regulation, custom, or usage of any state or territory, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, immunity secured by the Constitution and laws shall be liable to that party injured in an action at law, suit in equity, or other proper proceeding for redress. 1983 covers a lot. Conspiracy. 1985. Conspiracy to interfere with civil rights. If two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with the intent to deny any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to equal protection of the law. Well, that's our judges. Skoll versus City of Green Hills. The thrust of the plaintiff's complaint is that he was repeatedly deprived of certain fundamental rights by the concerted actions of the officials and employees of the City of Green Hills and by the judge of a court that had no jurisdiction to hear the matter. Sounds like what I've been arguing. The continuum of incidents inextricably entwined, which culminated in the plaintiff's conviction in the Green Hills Mayor's Court, demonstrates not that he was falsely accused or that he was falsely arrested or imprisoned, but rather that he suffered injury to his rights guaranteed under the Constitution, his right to counsel, to be advised of his right to a jury trial, to have the matter heard in a court of proper jurisdiction, and not to be sentenced in excess of the permitted penalty. It is not for this court to break down plaintiff's complaint down into isolated incidents, which would have taken separately, bear some resemblance to various state courts. This is because it is the series of events, the totality of acts done under color of state law, which have allegedly deprived the plaintiff of his rights under the Constitution, and it is this continuum of events for which there is no adequate state remedy. Get that? No adequate state remedy. That comprises a cause of action under 1983 that is broader than a common law tort. Federal courts have a duty to entertain solid claim on unconstitutional restraint by state under color of its law, and jurisdiction of federal court is not defeated by anything which may occur in the state court proceeding. These are very clear. That was an appellate and Court of Appeals ruling in federal court. Where fundamental rights are at issue, federal court should hesitate to abstain. That's what they constantly do. They don't want to address the right to a public trial, a jury trial, and all the other issues. They keep dismissing them. They find one excuse after another, but they're required to. When there is deprivation of constitutionally guaranteed right, duty of federal court to use injunctive power to interfere with the conduct of state officers cannot be avoided. I asked for injunctive relief to stop them. Nope. Take a hike. We're not doing anything. Where there is clear and imminent threat of irreparable injury amounting to a manifest oppression, it is the duty of the court to protect against loss asserted by temporary restraining order. In other words, I'm facing imprisonment in a closed courtroom. I'm being denied my right to a jury trial, as well as thousands of other people in the state. It's not just me. It's thousands. The cases in which injunctions have been issued against state officials, this is a New York State case, a long time ago, 1970. The cases in which injunctions have been against the state officials for violating 14th Amendment rights in the last 2 decades are legion. Such injunctions issue as a matter of right, where a violation of constitutional rights has been proved. This court has no discretion to deny an injunctive relief to a person who clearly establishes after trial on merit that he is being denied his constitutional. They won't let you go to trial. They dismiss the stuff off right. They don't want anything. It's just dismiss it, and all you get to read is the court's opinion. He didn't raise these issues when in fact they were raised. Suits may be brought against public officials to enjoin them from invading constitutional rights. Our Court of Appeals, this is the Second Circuit in New York City, no sound reason exists for holding that a federal court should not have the power to issue injunctive relief against commission of acts in violation of plaintiff's civil rights by state judges acting in their official capacity. That's very clear, and it's on point, but they do it anyway. Held that this act providing for civil rights for deprivation of rights embraces deprivation of both due process and equal protection of law. It contemplates such deprivation through unconstitutional application of law by conspiracy or otherwise, and it permits damages, including punitive damages. These laws, they're on my website. All this is in the federal court ruling, appeals, the complaints that were filed. In that letter I got back, showing the letter I sent out when I got first arrested for writing the letter, all this has been fully documented. Has made neglect a ground for bringing federally deprived claim as well as prejudice, passion, and intolerance. In addition to those grounds, the court has made a blanket denunciation of all forms of conduct which deny 14th Amendment rights by adding the phrase or otherwise after the above prescribed conduct. Judicial immunity. This is why they're covering it up a lot. Because as I was showing you, family court has to have jurisdiction. Kay, when I went through her, she was deprived of jurisdiction because she was the de facto owner of the Court of Appeals. It was in her care and custody of the building. It was under her supervision and control. Judicial immunity. Judges are not shielded by absolute immunity from declaratory and injunctive relief. Rankin versus Howard is one of the best cases out there for spelling it out. You have 2 types of jurisdiction. You have personal jurisdiction, which is jurisdiction over the person, and then there is subject matter jurisdiction, which does the court have jurisdiction over the subject matter. Personal jurisdiction, you have to be served with papers so you can appear. You are entitled to notice that you are there. The Supreme Court declared that state judges are immune from for judicial acts not taken in the clear absence of all jurisdiction. An absence of personal jurisdiction may be said to destroy all jurisdiction because the requirements of subject matter and personal jurisdiction are conjunctional. Both must be met before the court has the authority to adjudicate the rights of the parties to a dispute. Well, they took my mother's house. gave possession to my ex-wife. They never had personal jurisdiction over my mother. She was never served with papers. She was not allowed in the courtroom. They never acquired personal jurisdiction over her. Besides that, now, if a court lacks jurisdiction over a party, then it lacks all jurisdiction to adjudicate that party's rights, whether or not the subject matter is before it. It wasn't. But they had no jurisdiction over my mother. It has long been the rule that a valid judgment imposing a personal obligation or duty in favor of the plaintiff may be entered only by a court having jurisdiction over the person of the defendant. My mother was never served or anything else. They never had personal jurisdiction over her. But when a judge knows he lacks jurisdiction or acts on face of, in other words, he knows or he acts on the face of clearly valid state statutes or case law expressly depriving him of jurisdiction, judicial immunity is lost. I gave all the case law previously where these judges, they are not demonstrating jurisdiction. They have no right to rule on separation agreements. They have no right to determine marital property possession of it. They certainly don't have jurisdiction to determine non-marital property. So all these, what James did, all the family court judges. Now the appellate court judges would be acting within their jurisdiction because they hear appeals. The other judges weren't. The Court of Appeals was, except for Judge Kay in that one instance, had no authority to rule on the matter because her relationship to the building and that it was under her supervision and control. Judges do not have judicial immunity for their criminal actions in violating state or federal penal laws. That's why they're covering up. Judicial immunity is only available when a judge is being sued for monetary damages while acting in his judicial capacity. Furthermore, judicial immunity does not apply when declaratory or injunctive relief is sought. So, they have no authority. Their criminal acts on the bench, these phony court orders that they're issuing, those are criminal acts. Not having jurisdiction is a criminal act. They need to be prosecuted. The problem the state has, there's probably 99% of the judges, people could bring charges and they'd all be prosecuted. They don't want that happening. Doe versus N. Despite its fundamental and infectious purpose, the doctrine of judicial immunity is not absolutely unlimited. It does not immunize every judge, every state court judge, and every lawsuit. There is no official immunity from criminal liability. A state court judge can be made to answer criminally for violating the criminal provisions of the Civil Rights Act. We're going to go back to that again, but the Civil Rights Act, immunity applies only when judges are faced with suits involving their judicial as opposed to ministerial or administrative duties. Public servant. Now these are the definition. Any public officer or employee of the state or any political subdivision thereof or of any government instrumentality within the state. So it's anybody that's employed by the state. Criminal liability. When one person engages in a conduct which constitutes an offense, another person is criminally liable for such conduct when, acting with the mental culpability required for the commission thereof, he solicits, requests, commands, importunes, or intentionally aids such person engaged in such conduct. That's exactly what the attorneys are doing. They're allowing the judges to continue in violating people's rights when they know what the judges are doing is illegal. Tampering with physical evidence, we've already done that. Now, state officers held where state officers conspire with private individuals. In other words, state officers, judges conspire with, say, attorneys or support collection people or whoever to defeat or prejudice a litigant's right in state court. Litigants thereby denied equal protection under the color of state law and cause of action is created cognizable by federal courts under this section. Where it is alleged that the attorney joined or cooperated with or conspired in conjunction with the laws of persons acting with state officers who acted under state law, state action will exist. Rankin again versus Howard. The court held that immune judges' private co-conspirators do not enjoy derivative immunity. In other words, the judge may have immunity, but his co-conspirators do not. It follows that private parties who corruptly conspire with a judge in connection with such conduct are acting under color of state law within the meaning of 1983. So this is tying them all in. The doctrine of civil conspiracy extends liability for a tort, here the deprivation of constitutional rights, to persons other than the actual wrongdoer, but it is the acts causing damage to the plaintiff that give rise to the liability for damages, not the conspiracy itself. Oh, one of the things I had here is a little note. During an EBT on April 19th, my ex did not deny when asked that she was having ex parte communications with Judge James concerning the proceeding. Her answer was, "Not that I recall." Well, if you didn't have conversations with a judge, you would say, "No, I didn't." You wouldn't say, "Not that I recall." She did not deny when asked that her mother was heavily having ex parte communications with the judge. I don't know if her mother was or not. I would have objected. I would have denied it. 1983 action. Again, we went over that. Your 1983, 85. Dinwiddie, Gibraltar. Government officials may be held liable under 1983 either for overt acts that are illegal and harmful or for a failure to carry out their duties. That's the whole presentation I've given so far is based on that. That they're not doing their jobs, both the state and federal courts. Now, one of the things they like to do, and this is where they come in when you're being deprived of your rights, well, we can't get involved under the Younger doctrine. There are three things they have to look at under the Younger doctrine. There's an ongoing state court proceeding, an important state interest is implicated, the plaintiff has an avenue open for review of his or her constitutional claims. Well, that's not happening in New York State. The district court held that the state has a vital interest in family law and domestic relations. Yeah, they do. In depriving people of their rights and everything else. It will also note that federal courts do not educate family law matters. No, and that's not what was being asked of them. What was being asked of them to protect constitutional rights to public trials and jury trials, courts of proper jurisdiction. The issues of custody and are not one of the aspects of the cases. The issues before the federal court deal with support, the illegal taking of non-marital real property, the deprivation of constitutional rights as previously stated. All cases referred to by the district court in their decisions refer to custody and visitation issues. In cases being presented to the district court, we have contempt of court where imprisonment plus other sanctions are a distinct possibility, are being deprived of public trials. There are no important state interests in oh yes there is, cover up to protect the corrupt judges and attorneys. The district courts are refusing to look at the exceptions of the Younger doctrine. Younger and its civil counterpart, which we apply today, do of course allow intervention in those cases where the district court properly finds that the state proceeding is motivated by a desire to harass or is conducted in bad faith, or where the challenged statute is flagrantly and patently violative of express constitutional prohibitions in every clause, sentence, and paragraph, and in whatever manner and against whomever an effort might be made to apply it. Broad stroke. They say in the statute the court is open. It's not. They're lying. They're lying about, they don't fully address the issue of a jury trial. They didn't even address taking of the driver's licenses, the taking of your business license or your vocational license, your sporting licenses. Those are all added penalties. They didn't discuss it. And the federal court is refusing to do so also. They also exist. For any reason, the state statute being enforced is unconstitutional on its face or applied. Any prosecution under a patently unconstitutional is a deprivation of rights, privilege, or immunity secured by the Constitution. Well, if there's state law, a state statute, especially when you have Court of Appeals ruling saying they don't have the authority to do something, you're being deprived of your right to due process and equal protection of the law. The abstention doctrine is inappropriate for cases such as the present one where statutes are justifiably attacked on their face as abridging free expression. These sections, 28, what is it? There's a bunch of them, 13, 3, 4, to provide this court with jurisdiction to hear a claim that ordinances or state statutes are unconstitutional on their face or as applied. A district court should not, for reasons of commodity, abstain or decline jurisdiction to grant declaratory relief under the circumstances set forth in the present case. They're required. They shouldn't be doing it, but they do it in New York State. Another one. It would be justified were state officers threatened and are about to commence proceedings, either of civil or criminal nature, to enforce against parties affected an unconstitutional act violating the federal Constitution. They're violating it took me 4 years to get an open court proceeding. Nobody should have to fight that hard. That's a constitutional right. It should be granted. You know, there's plenty of case law here holding that what they're doing is illegal. Injunctive relief, which I tried on a number of cases, including my own, where there is a clear and imminent threat of irreparable injury amounting to manifest oppression, going to jail, it is duty of court to protect against loss asserted by right of temporary restraining order. Injunctive relief against higher officials is found to be good. Suits may be brought against public to enjoin them from invading constitutional rights. No sound, this is again a New York State Second Court of Appeals, has held that no sound reason exists for holding that federal courts should not have the power to issue injunctive relief against commission of acts in violation of plaintiff's civil rights by state judges acting in their official capacity. They ignore all this stuff because the corruption is statewide and is bound in every county family court. I don't know of an exception to it.